Very happy to be with you. And today I have seen such type of a web seminar which is being organized for law students especially. And you all know that All India the viewers of this web seminar should know what is the purpose in organizing these type of web seminars by All India Lawyers Union. What it expects from you who are the viewers in this web seminar. What I feel is that All India Lawyers Union is an organization which is almost working for the last 35 years for the cause of advocates and equally for the cause of common man. So the All India Lawyers Union is having its own constitution where we adhere to the preamble of the Constitution of India itself. So that is the main motto of All India Lawyers Union in organizing the activities where the interest of general public is also involved. Today's situation in India is also such a situation where advocates are supposed to be in support of the downtrodden people who are suffering a lot in this COVID-19 situation. And more particularly when the fundamental rights and the human rights of a common citizen is being affected, certainly it is the duty of advocates to come to the rescue of such type of people. And All India Lawyers Union is struggling for the rule of law in India also, which is fundamental to establish or to gain or to retain the fundamental rights. The rule of is to be set right. So nowadays, how the central government or the state governments are acting in COVID 2019 is also to be viewed by all of us, and how the common man is being affected. But the schemes those are being spread by central government or the state governments are not sufficient. Though these schemes are announced, implemented, they are not sufficient to reach. Now the All India Lawyers Union West Bengal Union, the students unit of All India Lawyers Union West Bengal has taken up such a special subject which is to be dealt by our guest lecturer Mr. Subhankar Nag, which is quite different to that of the regular subjects. That is to say, force measure of the observation of contracts in India during COVID-19. This is new and a special subject. You are all aware with regard to the 20 lakh crores of package which was announced by the union government, and this is the way in which the government is coming to. It is exhibiting that it is coming to the rescue of the entrepreneurs likewise. And certainly this situation may prevail for some more months also in India, which will affect the entire manufacturing system in India, or the contracts, which this today's subject with regard to the contracts which are already executed, entered in India. And what is the fate of those contracts, whether the same will be completed or the same will be deviated. Likewise, the discussion which we are going to hear from our guest lecturer Subhankar Nag is a special issue, because this depends upon a contract act. So a subject is also dealt in the name of today's session, and I expect and I hope that the viewers of this webinar, who are mostly students, are to keep it in mind that becoming an advocate is nothing. It is a common phenomena. It is quite natural. But becoming a service-oriented advocate, you must be aware with regard to the fundamentals and also preamble of the Constitution of India, basing on which if you people strive or struggle, certainly you will be reaching to the hearts of the common man. So All India Lawyers Union, All India committee also expect the same thing. And I, on behalf of National Executive Committee, Secretariat, and also Telangana, I wish all the viewers a successful carrying out the objects and what do you say, the service motto of All India Lawyers Union in West Bengal state especially. I thank the organizers for calling me to be with you, and I will be one of the audience or the viewers of the special subject to be dealt by Sri Shubhankar Nagaru. I thank the organizers once again. Thank you.
Good afternoon, everyone. I must first thank the organizer to give me the opportunity to make this to be a part of this session. So I am told that today most of the participants are students. So I will start this session.
Subankar, can you be a bit louder?
Okay. So today, I was told that most of the participants are students. So today I will try to be lucid, and I will try to start and conclude this session the easiest manner possible, so that the subject is, the participants can adopt and learn the subject. So to start with this force majeure and frustration of contract. Now in college days we learned it. When we start practicing, and when we are taught to draft an agreement, we are always advised to include a force majeure clause in the contract. So we are, as a matter of fact, when I was asked or taught to include a clause of force majeure in a contract, maybe 17, 20 years back, so I thought, what is the necessity? Now most of the practicing advocate also never had the opportunity in their lifetime to argue a point of force majeure or frustration of contract, because that happens rarely. And as a matter of fact, if you search the judgments delivered by Honorable Supreme Court, you will find only around 10, 12 judgments on this point, relevant judgments which really decide law. Now we don't get the opportunity to argue on this point, and this chapter is not touched. Now due to this COVID-19 situation, this pandemic, although it's unfortunate, but it is now a situation that within, say, 6 months, 1 year, we all going to face this situation, and we have to deal with that in our real life. A law student has to read judgments on this point. A lawyer has to argue cases, and almost every lawyer who is dealing in civil matters has to address this issue. So this issue is very important. Now to start with, now frustration of contract and force majeure. Now to start with, in a contract, we all know there is reciprocal obligation or performance. So if you are in a part of a contract, you have to perform. You have to discharge your obligation. You have to perform your part. Now, what if? Now, if you don't perform your reciprocal obligations or your performance, then what happens? You are charged with a penalty or whatever the consequence or damages in terms of the contract. Now, if a party comes and says that, see, this is a situation I am in, and in this situation I cannot perform my performance or obligations to deal with this. Now, what can be the situation? There can be multiple situations. That can be escalation in price, that can be anything. But that does not cover under force majeure or frustration of contract. Now, to come into this ambit, the performance or obligation has to be illegal, impossible, and due to events beyond the control of the parties. So the party who has to perform is, now it is beyond his control. He cannot perform it. Now it cannot be onerous. Say I am supposed to perform, I am supposed to supply some goods having a cost of 100 rupees when I entered into contract. Now when the time of delivery, the cost escalated to 1000 rupees, I say I cannot perform. So this is not a part. This is not a part of force majeure or frustration of contract or impossibility to perform it. Now say you agreed to supply your goods. Now government of India or state of West Bengal or any state in the country declare that item to be an illegal item. Then it becomes impossible and it is beyond the control of the parties. I will give the reference. Now, as you all know, the Indian legal system we inherited from the British, and the legal theory and the concepts all came. So we are also a part of common law system. Now England, before 1862, there was no concept of frustration of contract. There was no concept of frustration of contract. Now the frustration of contract, at that point of time, the law was, if you are in contract, come what may, you have to perform it. There is no other way around. You have to perform your contract, your obligations in terms of the contract. Now, let me give, to make this discussion more interesting, let me give an example. In 1647, a person bought a land, and what happened? There was a German invasion. And due to the German invasion, he could not use the land in question. But the court says, nothing doing, you have to perform it. But squarely, as you know, that covers under the frustration of contract, because the German enemy came and took over the position of the property. So at no stage of imagination he cannot utilize it. It is beyond his control. But court says no, you have to perform it. Now, only in 1866, 1863, in Taylor versus Caldwell, in that judgment, the British court ultimately found that the concept of frustration of contract. Now, what happened in that case? A party, there was a marriage hall, and there was a hall which was to be used for a purpose, and someone was lent advance for the use of that hall. Now, what happened? That hall was destructed in fire, and there was no ceremony. Now the one party claimed damages, and the question came up before the court, and court say, see, there was a fire, the court was burned, the hall was burnt, so you cannot get damages out of this. So that's where, from 1863, the concept of frustration of contract started. Now, interestingly, from 1863 that continued, and ultimately this concept was tested before Supreme Court first time in 1954. I'm sorry, it was first time tested by the Supreme Court in 1952 in the case of Gangasaran versus Ramcharan. Here, Supreme Court said clearly that this doctrine of frustration has no application in Indian. There is an Indian Contract Act, and in Indian Contract Act there are two sections, Section 32 and Section 56. Now, if it comes under purview of these two sections, there will be frustration of contract. And whatever happens, that comes under this Section 32 and Section 56. Now, in Section 32 says basically a contingent contract. So that is an event when you include a force-majeure clause in your agreement, and you say in clear words that there is a clause of force majeure in our contract, and due to this contingency that event cannot happen, and you get the benefit. So first thing first, according to the Indian law or law decided by the Supreme Court, if there is a force majeure clause, then you come under this Section 32 and you are supposed to get benefit. Now, if there is no clause, then it comes under Section 56. Now, how this Section 56 is quite akin to the concept of frustration of contract. A contract to do an act which, after the contract is made, becomes impossible, or by reason of some event which its promiser could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. So that is different. So now, under these two sections, you are entitled to get relief. A party is entitled to get relief, and you as a lawyer or a law student can advise your client to get. So if there is a clause, it comes under the purview of section 32. If it is a clause is not there, it comes under section 6. Now this judgment of 1952 was affirmed and was thereafter upheld by a 3 judges bench of the Honorable Supreme Court, and that matter went up to Supreme Court from the Calcutta High Court. Now this judgment is very important, and this is the law Supreme Court, Honorable Supreme Court settled, declared, and that is still valid, because even in 2017-18 judgments of Supreme Court follows this judgment. So those who are student, you please take down this citation, because that is going to help you, because that is the law and that is still date a good law. The judgment reported in 1954 SCR 310 equivalent cite. Let me repeat it again. 1954 SCR 310 equivalent citation you will get at AIR 1954 Supreme Court 44. Satyabrat Ghosh versus Mangni Ram Bangur and Company. So in that the judgment, Supreme Court also affirmed the earlier stand of Supreme Court in 1952, that was a division bench judgment, saying that the theories of frustration or doctrine of frustration is an essential idea, but that has no implication save and except this 56 and 32 of the Contract Act. Now that judgment was thereafter also followed in different judgments of Supreme Court. Now this is the proposition of law. Now there are various implications of that. I have already given an example of that. In case of increase in price, that will not be part of this frustration of contract, or the party who is unable to perform is also not supposed to get the benefit of that. And such theory, the performance has to be impossible, events beyond the control of the parties, and the other clauses of obstacles or some other nature that cannot absolve a party out of his inability to perform his duty. Now that is also echoed in different judgments of this Honorable Supreme Court and also of foreign judgments. Now let me give you an example just to make this session interesting. What happens, a person was supposed to deliver a goods to England through Suez Canal. Now there was a closure of Suez Canal and the party has to say that I cannot supply the goods. Because, why? Because the trade route has to be altered, as already altered, and we have to pay a hefty price for that. So if that is the situation, how can we perform it? The House of Lords says, the judgment is of 1961, says, no, you have to do it. Maybe it is not a case that you cannot supply the goods. The question is, the trade route is now longer, you have to pay a bigger price. But you have to perform this contract. You cannot get away from your obligations. So the situation is that has to be illegal, impossible events beyond the control of parties. Now let me tell you a recent example also. In 2016, Supreme a judgment. In that, kindly grant me a moment so that I can. Yes. So it was a judgment of Delhi Development Authority versus Kenneth Builders. Now what happened? Delhi Development Authority granted some kind of right to this Kenneth Builder and developers to develop a land in an area. Now when after the agreement, this Kenneth Builder started the development of the land in question. According to this Environment Act, this area became a part of forest land, and any kind of construction activity in that premises on that land was become illegal. So this Kenneth Builder approached court, got relief, and thereafter Delhi Development Authority DDA went up to Supreme Court. Now Supreme Court says that, see, if the obligation which Kenneth Builder was supposed to perform is illegal in terms of law. So if it is illegal as per law, you cannot enforce Kenneth Builders to carry on with his obligations in terms of the contract. So Supreme Court upheld the judgment of the Delhi High Court and granted relief to a person. So the person which faced this situation was legally, the obligation was illegal, and it was not to be performed by him, and the agreement therefore became vitiated by this situation. Now there is another example also. Thereafter, Justice Rohington's judgment, quoted in it is of 2017. Same situation, same kind of situation arose. It was a contract between Indonesian or Thailand company and an Indian company. Now what happened in that case? He was supposed to the Indian company was supposed to generate electricity. However, thereafter in 2003, electricity, the act was amendment and tariff regulation was completely changed. And thereafter, the Indian company was not in a position to complete it. So in such circumstances, Supreme Court again reiterated the situation and granted relief to the Indian company. So we see that if the situation is illegal or impossible to perform, then certainly you are going to get benefit. Now we have to understand it that in each and every case, the court has to analyze this situation, that whether indeed it comes under 32 or 56, and then only court can grant relief to you or to your client. So there is no straitjacket formula. Now, in this backdrop, let's now analyze the present circumstances we are in, or the future litigation which we are going to face. Now there is a pandemic, there was a lockdown for 3 months, and after this lockdown, now this lockdown is lifted. And what happens due to this 3 months period. Now the business was closed. The people was not even allowed to go outside their residence. Save and except there were regulations or timing, except that the people at large were not even allowed to go out of there. Now the question comes, what happens to diverse types of contracts which are in substance at that point of time? Because these 3 months, nobody were allowed to perform their obligations. Now I say most of the cases will come under this during this period of lockdown. But save and except those are in essential service. Now also recall that even in terms of these circulars issued under the Disaster Management Act 2005, there were some exceptions. Now a hospital was allowed to run, essentials were allowed to run, electricity company was allowed to run, and lot of company was allowed to run. So those who were allowed to run, they cannot seek benefit during the period of pandemic, during the period of this lockdown. No, they are not allowed to take benefit. But those who are closed, and they are closed due to pandemic, in addition to circulars, directives issued under the Disaster Management Act, they were unable. And somewhat working at that point of time was also illegal. So in that circumstances, save and except this essential part, they are entitled to, most of the persons are entitled to get benefit. Now there is also, now first of all, a recent case was filed before Delhi High Court against invocation of bank guarantee. It was urged before the court that there is a contract, I cannot perform it. Now to secure my contract, I have given a bank guarantee. So now the situation is such, the performance is impossible. So don't invoke the bank guarantee. Although that was it is an interim order passed in by the Delhi High Court in Vedanta Limited cases. The Delhi High Court, however, at that point of time, did not go into the niceties of this frustration of contract, but considering the overall circumstances on the ground of equity, passed order in favor of petitioner, saying that yes, the bank guarantee cannot be invoked. Now the person who was opposing that was Abhishek Manu Singh. He said that see, there is a force majeure clause also, and this force majeure clause, there is no word of pandemic written, and the bank guarantee can only be stayed in cases of fraud. I mean, that circumstances, can you grant interim order? But Delhi High Court granted him, and rightly did so. Even in force majeure clause, that is my interpretation of this. Maybe in the force majeure clause, the pandemic word is not in, because we have not seen a pandemic after 1920. So the word pandemic is not written in force majeure clause. But I am of opinion with construction in the enough force majeure clause or such interpretation for country to give justice to the parties. Now, what I said is mostly about all the contracts. But what happens in the contracts where transfer of property act happens? Now, here is a twist in cases of transfer of property. In transfer of property act, you are not always going to get the benefit of this decision. Now, the transfer of property act, according to the judgment of Supreme Court also, in case of a transfer of property act, the section 108E will come into play. Now, it's my opinion that if there is a force majeure clause already in a contract, that has to be taken care of. But if there is no clause, say we are talking about section 56 situation. Now, in that cases, 108, section 108E will come into play. So it says like, if by fire, tempest, flood, violence of an army or mob or other irresistible force or any material part of the property by wholly destroyed or rendered substantial or permanently unfit for purposes for which it was laid, the lease shall at the option of the lessee be void. So if such situations as mentioned in section 100, now if such situation due to pandemic in case of transfer of property act, the court has to look into section 108E and not section 56 of the contract. This is also the law settled by the Honorable Supreme. Now the question comes, I am really looking forward to see this interpretation, because see, most of the leasehold property are not destroyed. They are not destroyed fire or by something. But there are two part of argument can be advanced. One, landlord can say, officer can say, I see, I have already parted with the property. Now how you are going to use it, there is no fire, nothing. The leasehold premises were there, ready to use. So if you can't use, it's no problem. I am not going to suffer the loss. And the lessee's argument is to be that, see, I was not supposed to even go out of my house. How I am going to use the premises? No, I really, not in near future, but really see the fate of this confusion. There is a gray area according to me. And this area has to be answered by courts of the country. Now, one thing we need to keep in mind, that this situation only applies to a subsisting contract. If a contract is already concluded and in that event some residual obligation even after contract, the contractual period is over, is left open, that won't cover either under section 32. See, in terms of contract, you are supposed to render some service. You could not within the time, say before in the month of February 2020, the contract was expiring. You could not do that. You are supposed to do that in the month of March. So you are taking, you go to court and take benefit of this situation, of this force majeure clause. No, you are not supposed to get that. To attract the provision of section 32 and 36, the contract has to be in existence and subsisting. Now, 2-3 things during this period has also happened. We also need to understand that. Now, in this case of government contract, the central government has already issued stating this will be the account as force majeure situation and no penal steps or no other steps can be taken. But that is only restricted to government contracts only. And this general circular was issued so that the litigation is reduced, the amount of litigation or the litigation going to face the Union of India and the parties, that needs to reduce. Now we also can get benefit of this situation that the Union of India is, we can only rely, because those are contracts between the central government and the contractors where you are not a part. But you can take reference that even Union of India accepted the situation as a force majeure situation. Now, another thing that is also advisor is there also, that you cannot terminate any contract of an employee, or you have to pay the entire salary of the employee. Or I would say that these are advisories. Central government of India has issued some advices. Now it's up to the party whether they are going to keep this advice or not. So these advisories is not binding on any party. This is one thing. And Transfer of Property Act I have already covered. So again, before concluding, I want to say that there is no schedule. This is the law, and yes, of that this law has to be assessed by our court, case-to-case basis, and give benefit to the parties who are entitled. So on the basis of this, I think I made a lucid and short session, so that which is quite easy to understand to students at large. Now moderator can invite questions, so that any confusion is there, I can.
Thank you, Shubhankar. Yes, Mr. Badi, you have already attended several sessions. So,
Mr. Raha, I am taking 2 minutes.
Yeah, sure, Shubhankar. Already, Mr. Badi, you have attended our previous sessions also. So we have discussed the force majeure and frustration of contracts with regard to the Indian context. Other than that, how about this topic? How do you feel that this topic, the students and juniors will be benefited?
Thank you, Mr. Raha. Good afternoon to the organizer, the speaker, and the participant. I have already attended a few sessions of this program, and this topic is very much relevant. The concept of force majeure and the concept of frustration. You know that the law of contract, I have seen yesterday that this contract law of your country and our country the same. The contract law of 1872. There is no basic change I have found. So we have to dealt a lot of cases arising out of the contract, violation of the terms of contract, enforcement of contract, and also some arbitration proceedings arising out of the contractual obligation. And I will just tell some few words about my own case. I have dealt so many cases, but the first case I met with the plea of force majeure in 1995. You know that in 1991, there was a great cyclone in Bangladesh causing the death of 1,50,000 people and the coastal belt of the Cox's Bazar and Chittagong and the destroyed seriously, and more than 1.5 billions of dollars the damage cost. So my clients, 3 clients of the same nature, they had contact with the Fisheries Development Corporation of Bangladesh under the Ministry of Fisheries. They are to supply the fingerlings. Fingerlings and understand the যারা বাংলা আছে যেটা হলো যে চিংড়ি মাছের হলো পোনা এটা, হ্যাঁ, fingerlings, and they have to supply it by 30th June 1991. But the devastation cyclone, it took place on 29th April 1991. And for this reason, my clients could not deliver the full supply. And for this reason, they have intimated the Minister of Fisheries about the cyclone, that is the, and ultimately there is an arbitration. And while reading the papers, I found that in the clause, to the general terms and conditions of contract, there is a clause of force majeure. It is specifically written that any act are prevented by the war, aggression, epidemic, cyclone, terrorism, and the cyclone definitely comes within the purview of force majeure. And I took up this plea in my statement of claim, and I also adduced oral documentary evidence, and ultimately I got the award in 3 cases. And Mr. Shubhankar Nag has already discussed in details the backgrounds of these 2 terms. And you know that the students, particularly in our Contract Act, the term force majeure and the frustration of contract, you will never find in our contract law. As Mr. Nag has already discussed the historical background, the force majeure, it is a French term, and it originated from the Latin this measure, that is a maximum force or powerful force, and these have been originated from the common law, civil law system, that is the French law is originated from the Roman law, and they have in their code, the Code of Civil Code of France, perhaps Article 1218, the specific clause in that civil code. And this ultimately was interpreted by the our common law systems, as Mr. Shubhankar has discussed, both the doctrine of frustration and the doctrine of force majeure, that relief was not given in the earlier cases, in the case of 1647. But the English law, the English legal system has interpreted these terms. And the force majeure, it comes from the common law, civil law systems, and the latter comes from the English legal systems. So this factor is relevant also in our country, because a lot of cases will be filed during this lockdown, even after the lockdown is over. And as Mr. Shubhankar has said, and we have seen that several cases have been filed in the Delhi High Courts and also in the Bombay High Courts, and some petitions, that is under the Arbitration and Conciliation Act, have been rejected, and in some of the cases the relief has been given. And finally, I conclude that the discussions advanced by Mr. Shubhankar Nag he is well experienced in this matter, has discussed the two terms in relation to the law of contract, that is section 32 and section 56, and the decision of the House of Lords and of the Indian Supreme Court. And I think he has made it clear to the students. And the students and the young lawyers, they will be benefited. And because they have to fight such type of cases in future after the lockdown period is over. So on behalf of the Central Executive Committee of Bangladesh Democratic Lawyers Association, I thank Mr. Raha and Mr. Shubhankar Nag and all the participants. Thank you very much.
Thank you, Mr. Bari.